Okay, greetings everyone, and welcome to this very exciting book launch of Dr. Ndjodi Ndeunyema's new book on the human right to water. We're going to hear more about that. I'm Professor David Bilchitz, a professor at the University of Johannesburg and the University of Reading, and also director of the South African Institute for Advanced Constitutional Public Human Rights International Law. And I welcome you to this wonderful event. We look forward to a discussion of Dr. Ndeunyema's book. We also mentioned to you that we have continual and fascinating seminars throughout the year, and you are most welcome to join those seminars. And those who wish to be added to the list, I will post a link where an email address for you to send to be added to the list about all our events. But without further ado, I'm going to hand over to Ms. Rophafatso Maposa, who is going to chair this event. Over to you, Rophafatso.
So much, Prof. Bilchitz. Good afternoon, everyone, and welcome to the online launch of Re-Invigorating Ubuntu Through Water. I'd like to thank Ndjodi for trusting us with this launch, and we look forward to hearing more from you about the book. Before I begin, I'd just like to hand over to Natalie Roosman, who is a representative from the CAS Namibian organization. Ms. Natalie.
Yeah, very good afternoon. Thank you very much for giving the opportunity as a Konrad Adenauer Foundation here in Namibia, located in Windhoek, to give a few opening remarks. Dear Dr. Ndjodi Ndeunyema, Professor Tsonga, and Dr. Sunyapi, on behalf of the Konrad Adenauer Foundation, Namibia and Angola office, we feel honored to be part of the launch of this important book titled Re-Invigorating Ubuntu Through Water, a human right to water under the Namibian Constitution. I'm saying it is an important book, not just because I would like to put a smile on the face of the author, but because this book addresses issues pertaining to a resource that is so fundamental to the life on Earth. Although water is said to be available in abundance, it has become scarce for human use due to change in the rainfall, resource privatization, as well as human activities that lead to pollution. There's an economic water scarcity, mostly in the global south here in Namibia, meaning that there is little or no investment in water resources, technology, and infrastructure in some places. This had led to poor sanitation and an inability to produce enough food for all. Water can also be a source of conflict if it's not shared equally, mostly where it has a transboundary resource. For instance, like on the bordering situation between Namibia and Angola. It is from this perspective that in order to ensure availability of water for all, water must be treated as a basic human right. Every human on Earth deserves access to water unconditionally. The launch of this very important book is indeed helpful in promoting issues of human rights and enhancing constitutional and democratic structures, which are integral to the Konrad Adenauer Foundation. To promote the rule of law, human rights, international and African dialogue, and networking. Indeed, the Konrad Adenauer Foundation continues to work toward enhancing access to information and therewith sensitizing Namibians of their rights as it's written in the Constitution. This book, ladies and gentlemen, is a catalyst helpful in attaining our mission at CAS and also the UN Sustainable Development Goal number 6, which states everyone on Earth should have access to safe and affordable drinking water. Dear guests, I'm positive that this book and the launch of this book will go a long way in emphasizing the importance of open dialogues about water-related issues with human rights, which will help in making sure that water is easily accessible to the poorest and vulnerable members of our society. So I'm very much looking forward and hope that all the participants and the audience will enjoy and have an enlightening moments with this book launch. Thank you very much.
Thank you so much, Natalie. Before we begin, I'm just going to give a quick outline of the book. Of course, the detailed analysis is over to you, Ndjodi. I'm sure people would like to hear more from you about the full outline of the book. So Re-Invigorating Ubuntu Through Water argues for the existence of enforceable human rights to water that is implied from the right to life in Article 6 of the Namibian Constitution. The book builds this argument by using tools of constitutional interpretation and the aid of comparative materials. As such, the African value of Ubuntu is invoked. Ubuntu, which is legally developed through its 4 key principles of community, interdependence, dignity, and solidarity, is anchored in a novel approach to Namibian constitutional interpretation and conceptualized as re-invigorative constitutionalism. The book advances the aqua content of water, and aqua in this context stands for adequacy, quality, and accessibility. And this is articulated together with the correlative duties, which include respect, protection, and fulfillment of the duties imposed upon the Namibian state as the primary duty bearer of the right to water. And so from your discussion, Ndjodi, I'm sure we'll see how you interact with different interpretative resources from international law, including the General Comment number 15 from the United Nations Committee on Social, Economic, and Social Rights, as well as the African Commission's Principles and Guidelines on Social and Economic Rights. Now, just to introduce our author very quickly, Dr. Ndjodi Ndeunyema holds a Doctor of Philosophy in Law from the University of Oxford and was awarded the Dr. Sura Subedi Prize for the Best Law Doctoral Thesis submitted at the Oxford Law Faculty in 2019. So this is the thesis on which this book is premised. And Dr. Ndjodi also completed the MPhil in Law, the BCL, and the MSc Criminology and Criminal Justice at Oxford University as a Rhodes Scholar. Dr. Ndeunyema was also a Modern Law Review Early Career Research Fellow at the Oxford University between 2020 and 2021. And from 2017 to 2021, he served as a research director at the Oxford Human Rights Hub and was a co-founding editor of the University of Oxford Human Rights Hub Journal. Your CV is very long, Dr. Ndjodi, but let's hand over to you to hear more about the book. Thank you.
Fantastic. Thank you so much, Rupa. I hope you can hear me well. And thank you as well, David SAIFAC, for hosting me. I'm delighted that a virtual launch of my book is being hosted by SAIFAC because I have great respect for the work of SAIFAC over the years. And David, of course, I've relied a lot on your philosophical thinking of many of the issues that I ultimately developed in the book. So in many ways, it's an intellectual homecoming. Also, thank you, Konrad Adenauer, Mrs. Roosman. You're sort of just across the road. Maybe we should have been in the same room because I'm seated close proximity to you. But I think you've set the scene quite well in terms of the importance, the timeliness of the subject matter of water rights, and the timelessness of the subject. Because yes, water scarcity issues are with us. They've been with us. They will remain with us. Of course, I look at it from a Namibian perspective, but certainly as Ms. Roosman clearly outlined, these issues are of universal appeal. So I thought I'll just share a presentation briefly outlining what the content of the book is for those who haven't had an opportunity. And of course, I'm looking forward to the critical engagement of Professors Zongwe and Soyapi, hopefully generous as well. So in terms of the water scarcity problem, so that is, well known in the Namibian context. And I, in the book, outline very briefly what the water insecurity, inequality problem looks like and the face of it, so as to move away from the theoretical construction, but realizing that the theory would ultimately, hopefully, benefit those individuals and communities that are on the receiving end. So I capture there some of the issues that have struck me, particularly when I landed on water as the social economic right that I would focus on. in terms of developing its philosophical foundation in the Namibian constitutional setting. Water disconnections for non-payment are often reported. The indignity of water scarcity. So yes, we do not have in Namibia people who are necessarily reported to have died of thirst directly, but there are, if you want, indirect causes of a lack of water, which include people who die digging traditional wells and the wells collapse on them. There have been reports of that nature. The peculiar situation where we have a body or bodies of water and people have proximity to them, but in order to access those bodies of water, they have to risk life or limb. And this is seen predominantly in the northeastern part of the country along those rivers. Those who access the rivers for either water for cleaning, the personal domestic use, fall victim to river crocodiles. So clearly there's a water issue there. And of course now in Namibia, and over the last few weeks, we've been having a debate as to whether or not our water utility should be a for-profit entity. Now, of course, the water issue in Namibia isn't all gloomy. And there's a lot of water potential in Namibia as well. And I highlight some of the water potential in Namibia. The Ohangwena aquifer in the northern part of the country has water that can satisfy the northern part of the country for an estimated 4 centuries. Of course, the quality thereof would need to be treated and so forth, but in theory, there are quantities of water that are available. There are desalination prospects that are in the pipeline, and government has instituted plans for water catchment, including a newly finalized high-capacity dam called Necrotal Dam in the very dry southern part of the country. So the book really tries to weigh into this debate in a solutions-centric manner and be forward-looking with the view of bringing dignity to all. So the book also takes an anthropocentric approach. So the focus is on water for personal and domestic use rather than for commercial interests. And the reason why I took that approach is because I was looking at the case law, as one naturally would, to try and establish if there has been any case law on the human rights to water or water rights more generally, particularly if it's statutorily derived. But all the cases that relate to water rights in the statutory setting are water cases in the commercial context. So, for example, I have indicated there a farm, a commercial farm, versus a uranium mine. And the issue there was the alleged over-abstraction of water by the uranium mine to the commercial detriment of the farm. The water utility in another case versus a commercial farm that produces grapes for wine. And that was a breach of contract setting. And another case where one Mr. Kamanya had a farm in the northern part of the country in order to sustain his commercial, semi-commercial farming activities. He contracted with Mr. Smith to drill a borehole. Mr. Smith did not deliver as per contractual agreement, and therefore Mr. Kamanya sued Mr. Smith. And in advancing his argument, Mr. Kamanya predicated his commercial interests in water rights that are statutorily recognized. So my thinking was, these commercial entities clearly have the means, the power, the redress to vindicate their water rights. But we have communities and individuals who, for non-commercial reasons and for purely domestic and personal use, do not have access to water. So surely the courts have something to say about this social injustice situation. So in terms of the overview argument that I advance, I conclude that there is a court enforceable human right to water under the Namibian constitution, in as much as it's not express. It is to be implied, I argue, from Article 6, which is our right to life provision. And of course, implying rights requires a robust approach to constitutional interpretation. So I, in the book, work through the various theories of constitutional interpretation in a really fascinating way, because there's limited scholarship that really rigorously seeks to tease out the various macro level constitutional theories and apply them to the Namibian setting. So for example, originalism I apply looking at the drafting history, which offers us a significant number of resources, and the 1982 principles. So even if we were to apply a original intent approach, which is not necessarily the argument that I would advance, that wouldn't or would still be able to sustain an argument for an implied right, because the founders of the Constitution were not or did not intend, from my argument, which is informed by the literature and resources available, to exclude social economic dimensions such as water as court enforceable rights within the framework of our fundamental Bill of Rights in Chapter 3 of the Constitution. In addition, textualism, purposivism, and transformative constitutionalism, all of which are theories that find varying levels of application in our constitutional interpretation approach as ordained by the Supreme Court through various decisions over the years. So purposivism being the anchor, transformative constitutionalism, obviously South African inspired, exported to the global South, but the texture thereof retaining character in the Namibian setting as well. I'm somewhat dissatisfied with these theories of constitutional interpretation, and at the same time argue that they, particularly transformative constitutionalism, can be supplemented in order to invigorate or reinvigorate African values within our legal culture, as I argue. So this is where this umbrella notion of reinvigorative constitutionalism, which I novelly conceptualize and justify through various textual means, enters the debate. So that's really the umbrella theoretical framework that I put forward in order to then justify using Ubuntu to inform our understanding of the right to life, to then give birth, if you want, to an implied right to water. It's perhaps worth mentioning that the argument I advance in the book is built on a constitutional pedestal. And the reason why I do it at constitutional level is because, yes, the relatively new Water Resource Management Act has a human right to water-esque approach in particularly Section 3A, but that is obviously a legislative instrument. And I wanted to build a durable, timeless, robust, permanent right to water argument that is anchored in the text of the Constitution and entrenched within the safety and permanence of Chapter 3 of the Constitution. So that is to ensure that the principle of a human right to water, implied as it may be, will endure beyond any given statutory majority, given that legislation would only be a 50% plus one majority away from amendment, repeal, and so forth. Coming back to this theoretical notion of reinvigorative constitutionalism, and I think especially in the scholarly setting, this debate is quite important, and I would really welcome a critical engagement with this theoretical approach. It is built on a decolonial theory, which seeks to translate that theory of decolonization of legal culture, particularly, into the substance of how we argue constitutional rights, and moving away from the legal imperialism that I argue that was the hallmark of the colonial and apartheid projects in Namibia, Southern Africa, the global South more broadly, and that requiring us to be deliberate about reversing that legal imperialism through the enthusing of African values into the legal culture, and I identify specific textual anchors to justify this theoretical approach, in addition to the philosophy. So the textual anchors include the preamble. It refers to colonialism, apartheid, and so forth, as effectively setting the scene for why the Constitution was adopted. Article 19, referring to the right to culture, the right to culture being a fundamental right. And in so doing, I latch onto some of the jurisprudence that has interpreted the right to culture at African charter level, which includes the right to have one's culture reflected in the legal system that ultimately regulates our daily existence, as well as Article 66, which places common law and customary law on par in theory, but our common law is still superior in the sense that when there is a dispute of law or of fact, the courts would ordinarily have primary recourse to common law, when I argue there are also customary law derived approaches that can be embraced and brought into the law, as is the constitutional instruction to recognize common law and customary law on par, in as much as I argue that customary law should be given some preeminence, given that the common law is already entrenched and has historically been entrenched. So there's deliberateness that is required in order to subscribe and be faithful to that constitutional instruction. In addition, the viability and value of the Human Rights Project is something that I focus on, that human rights will only gain traction and legitimacy culturally if they are recognizable to the communities that they seek to serve. And in so doing, if we have a human rights project in Namibia and beyond that clearly derives its philosophical reasoning from the communities within which it operates, that can cultivate its legitimacy in addition to its inherent legality, that being important for the ultimate viability of the project. So reinvigorative constitutionalism, African values, I then identify specifically Ubuntu, and in the book I extensively discuss Ubuntu, its origins, etymology, justify why Ubuntu, address the objections to Ubuntu, which is a debate that happened in yesteryears in the South African setting, and rebut those objections, whether constitutional, normative, and so forth. Compare Ubuntu, for example, and its appropriateness to water disputes to a doctrine such as the riparian doctrine, which is an English common law derived doctrine. And I argue that it would be inappropriate to have recourse to an English common law doctrine, which defines how, for example, contiguous neighbors who share a body of water, such as a river, would deal with that shared resource, when we have Ubuntu, which can also inform us on these shared resource challenges and so forth. I rely on anthropological literature as well to argue that Ubuntu is a truly African value that cuts across even the North Africa, sub-Saharan Africa divide. And in as much as I identify Ubuntu and use Ubuntu in its isiZulu version, there are other linguistic renditions of Ubuntu, Ubuntu, and recognizing that Ntu, Nu, suffix in African languages has a common value genesis of humanness. I move on to identify and derive the legal principles of Ubuntu, relying on literature such as that of Professor Himonga, who has done extensive work on this. She extends it to six principles. I identify only 4 for purposes of the book's discussion. And those principles then giving rise to positive obligations upon specifically the Namibian state as the primary duty bearer as regards the realization of the right to water of individuals. So the socioeconomic context of Namibia, very briefly, we have a chapter 3 of the Constitution that has a preeminent focus on civil and political rights, life, dignity, free speech, and so forth, with limited reference to socioeconomic rights. Again, I mentioned that the original intention approach wouldn't defeat an argument to imply socioeconomic rights such as water in our Constitution. So I deal with that, and then I also have large recourse to comparative cases for obvious reasons, in that rights to water jurisprudence is non-existent in Namibia. South Africa has such jurisprudence, most notably in the Mazibuko matter. Of course, South Africa's constitution has a express right to water, which is not present in Namibia. So Mazibuko does have a lot to offer, but it doesn't necessarily allow us to overcome that textual normative challenge that we would, as a first step, need to overcome in the Namibian constitutional setting. So I then look at jurisprudence from Botswana, also no express right to water, but the courts in Botswana have taken an interesting approach in this Motselanyane decision, where very briefly a community was deprived of the use of an existing borehole by the government of Botswana because they had adopted a policy that would create a reserve, and therefore the borehole was turned into a white elephant in order for the community, which is an offshoot of the San population, to move away from that area. The court found that there was a violation of the right not to be subjected to cruel, inhumane, and degrading treatment, which is effectively an indirect right to water. Obviously not ideal, but demonstrative of the fact that the argument can be approached from different perspectives, in as much as there's a textual absence of an express right to water. Also, extensive reliance on implied rights, looking at Indian courts. Hamid Khan decision, an interesting decision where the court found that the state had violated the duty to fulfill a right to water, where water had excess fluoride content. There's also a chapter that is dedicated to a human right to water under international law. And in a nutshell, that chapter first deals with the question of how international law applies in the Namibian setting. So a rather theoretical but important argument, especially in the context of human rights, because certain human rights are derived from regional and international instruments. So treaties, customary international law, and general principles of law, I argue for a qualified monist approach in contrary to the existing literature. I don't go in too much of the weeds of that argument and give a somewhat adumbrated version of that argument, because I deal with that argument of the existence of a general human right to water under international law, those 3 sources that I mentioned, in another paper that is published in the Michigan Journal on International Law, which I would encourage you to have a look at, and which will hopefully carry even more currency going forward, given that there's this desire to move towards a express human right to water at international level, building upon SDG 6, as was mentioned earlier by Ms. Rusman, so that there's a legal obligation, which legal obligation is also important in the context of these transboundary water disputes that we're seeing, Namibia, Angola being such an example. Much of northern Namibia's water is derived from the catchment area in Angola. So if Angola, for example, were to put up infrastructure or something of that nature, which restricts the free flow of water down south into northern Namibia, that effectively will thirst that northern population. Is there an argument to be made for Angola to respect the human rights to water in that interstate context? Debatable, potentially feasible. Again, south of the border, the dispute hasn't fully fomented yet, but a dispute nevertheless between Namibia and South Africa as to really the ownership of the Orange River. South Africa canaling the Orange River, effectively preventing the free flow of water to the streams along the border, restricting the amount of water there that is available for Namibian use as a shared resource. South Africa arguing that the border is north of the Orange River rather than in the middle, allowing for an equidistant approach to that shared water resource, as well as then allowing South Africa to effectively have exclusive use of the river potentially, as well as any mineral deposits, potentially a right to water argument that can be made as to defining what principles should decide that territorial boundary dispute. All these, I think, then make the right to water, human right to water argument at the international level relevant. And looking beyond, examples cannot be exhausted as regards the right to water. The Nile, a millennia old dispute, again fomenting with the dam that Ethiopia has constructed, rights to water arguments for downstream states potentially. Wherever you look, there are right to water disputes, both domestically and internationally. So hopefully, in as much as the book is anchored in the Namibian setting, we can also gain perspective for non-Namibian international issues. So the scarcity of water issue was mentioned in the earlier remarks as well. And I complicate this notion that there's a water scarcity problem by relying on scholarship, especially in the justiciability of the rights to water context, that basically typologizes water scarcity into first order scarcity, which is the physical limited availability of water as a resource. And that's just a factual problem. Whether it's Namibia or the DRC, water in many ways is a non-renewable resource. So you will always reach a state or stage of scarcity, but it's relative as to where you fall on the scale of scarcity, I would argue. But I complicate it to argue, as Olson does, that there's a second order scarcity problem, which is we have water resources. Yes, they aren't optimal, but many a times the problem is our adaptive capacity as societies, which face the inherent first order natural resource scarcity to manage such a scarcity. So I argue in the judicial setting that our institutions should be strengthened in order to facilitate institutional change as appropriate to the second order scarcity at hand, which is social resource scarcity. So these distributive questions for the limited resources that we have, where we see that those who have societal power, whether political, economic, class, and so forth, would access that resource with relative ease to the detriment of those with limited or no power, or limited or no voice, or perhaps, as Arundhati Roy encourages us to think about it, those who are preferably unheard in society. So that's where the adjudicatory legal accountability that courts introduce to the argument, I think, plays a role. And of course, addressing this issue of the politicization of water, hydropolitics, where water has for too long, especially in an African setting, been a political tool. And I argue that water is a human right, not a matter of politics, charity, benevolence, or goodwill. And that is a principle that is seen in the Nairobi Principles by the African Commission. I also addressed the various so-called justiciability, technical justiciability issues. So textual justiciability, the constitutional design of Namibia. We have a chapter 11, which includes Article 95, which outlines the state's welfare principles, which include references to social and economic goods, not rights, but goods. So a careful treatment of that language and scrutiny thereof for interpretation purposes. Those Article 95 provisions being contrajudicative per Article 101, looking carefully at the language of Article 101, particularly because the scholarly approach has been to accept defeat as to the justiciability of socioeconomic rights in the Namibian setting, because we have these principles of state policy. But I argue that that is by no means fatal. So from a purely constitutional interpretation point of view, if you're implying a right to water from Chapter 3, which is in many ways the heart and soul of the Constitution, you can't then introduce a redaction to that implied right by having recourse to provisions that are outside the framework of Chapter 3. Once it's in Chapter 3 and there's a coherent normative argument why such an implied right should be embraced, then it's court enforceable, adjudicatable, and even if there was some currency in Article 95, such an argument wouldn't then negate from a court enforceable human right to water. And of course, dealing with various institutional justiciability concerns that may arise. And of course, in the Namibian setting where we're not accustomed to courts weighing in on social and economic rights issues, as you would have it in South Africa and increasingly in jurisdictions such as Zimbabwe and Kenya, in many ways, rudimentary questions of the court's legitimacy, capacity, and competence to deal with these polycentric distributive questions would arise. I deal with them within the book, both from a theoretical point of view and also looking over the fence, if you want, by demonstrating that this has been done, so we wouldn't necessarily be charting uncharted waters, no pun intended, and polycentricity and so forth. And I do it so through a deliberative democracy model, which addresses any issues that arise as regards the separation of powers, for example. I also dedicate some space in the book to dealing with this issue of the mirage of the justiciability of the right to water. So I caution the reader that in as much as, yes, we may be in agreement that there is an implied court enforceable human right to water that can be derived from Article 6, right to life, or potentially even Article 8, which is the right to dignity, but for the purpose of my argument, I focus on the right to life. We should be cautious of not having a right in the language of the European Court, famously, that is theoretical and illusionary. And by that, I refer to somewhat of the optical illusion, which is captured aptly, I feel, by the cover of the book, which is pictured there, where you see that there is this tree in a body of water, a petrified tree that is leafless. So it's in a body of water, but it's leafless, and it's perhaps alive, but it doesn't have all the features of a fully fledged flourishing tree. A large body of water in a semi-arid environment. So yes, the environment, the immediate environment around the body of water it has proximity to the body of water, but it doesn't show, which is the irony that we see in Namibia in many ways, communities that have proximity to water but have no right to water in practice. But I look at this from the perspective of the court processes that we adopt, the restrictions, technical restrictions that would arise and that we would need to address as the Namibian legal fraternity through jurisprudential development, but also deliberate reforms as regards legal costs, this adversarial model and its propriety as regards adjudicating social and economic disputes, and also legal standing rules that are common law derived, primarily common law derived, but extremely restrictive as it stands. So in terms of the content of the right to water, I dedicate the latter chapters of the book to this discussion. I latch onto soft law sources, including the WHO's Drinking Water Guidelines, General Comment 15, as well as the Nairobi Principles of the African Commission, and I do so with caution to justify why these soft law sources should be interpretive aids in our Namibian setting. I developed the aqua notion of water, so water as available, of quality and accessible, in an act of remarkable innovation to typologize the issue and hopefully allow the reader to better understand how to address some of these issues, and of course identify the state as a primary duty bearer, not the only duty bearer, but for purposes of the book, the focus of the book, recognizing that non-state actors and third states, so for example, Angola, South Africa, Botswana, in a reciprocal way with Namibia, would also have such obligations. This debate of the minimum core, which is at some point was rife in the South African setting, I try to import it in the Namibian setting and recognize that there's actually language that is synonymous with the minimum core obligations principle that has a derivative in various international treaties in our Namibian constitution. So Article 22A, referring to the essential content of a Chapter 3 right being non-derogable. So I looked at the literature that informed the treaty approach to minimum core, where there's a core right to in any right has a core, and there's a circumjacent, and I identify that any given right, including water, has a core which is immediate, and the challenge in Namibia is that many communities and individuals do not have that core protected, which is in many ways non-derogable and low-hanging fruit from the perspective of litigating a right to water, in addition to the general obligations, which can potentially be programmatic, but because they are programmatic and resource dependent and progressive, it does not mean that they cannot be subjected to judicial accountability. So that is really the outline that I had prepared of the book. I'm not sure how much time I took, but I will hand over to Ropa to then carry forward the rest of the conversation.
Thank you so much, Ndjodi, for that analysis. I think it's really great to hear more about your thought process as you wrote the book, despite having read a few chapters myself. So it's really great to hear what your thought process was behind most of your submissions. And I'm going to hand over to our discussants to hear what they think. So our first discussant for today is Prof. Zongwe. He has already written a short review on African Law Matters, which is a blog that is initiative here at SAIFAC. And one of the things he said in the review was that re-invigorative constitutionalism shines a new trail in the water jurisprudence by the manner in which it combines transformative constitutionalism and the ethos of Ubuntu. So I think he agrees that your take on reinvigorative constitutionalism from the book is great. A short bio about Prof. Zongwe. He wears many hats as an author, academic, and a consultant. He is currently an associate professor in the Department of Legal Studies at Walter Sisulu University. From 2015 to 2018, he worked at the University of Namibia, where he taught several modules in the Faculty of Law. Prof. Zongwe has consulted for many organizations and presented lectures at more than 60 conferences and events, and he has also received several merit awards. He studied at the University of Namibia, the Université de Montréal, and Cornell University, where he earned his LLM and JSD degrees. Prof. Zongwe, I'll now hand over to you.
Thank you very much, Roba. Can you hear me? Yes, so I'll take it where you have, in a sense, left off when you say that I said it was a trailblazing book. I fully agree, and in the discussion that I'm going to lead, I hope that will also that will come very clearly. So first of all, thank you very much for attending this book launch. And I'm happy to see Ndjodi. It's a great privilege, or I should say, Dr. Ndeunyema. It's a well-deserved title. So it's a great privilege for me. It's a great privilege to be part of this book launch. Among Ndjodi's spectacular achievement is also the first Oxford PhD from the University of Namibia. The University of Namibia is a relatively new university. It was established in 1992, so I'm even older than the University of Namibia. So that is one of the reasons why it is a privilege. It's also, I was also privileged to have, I remember that when Ndjodi was still doing his PhD studies, he showed me a draft of one of the chapters. I don't think I was qualified to provide my insight on what was already quite a piece of great scholarship. So thank you. I appreciate the gesture. As I said, I don't think I was that qualified, but it's a real privilege. I'm going to engage you in a critical discussion, but it's not going to be criticism for the sake of criticizing. It's going to be criticism to force you to basically agree or disagree with me, so that in the process, I will nudge you toward Ndjodi's book, which is, in my view, a shining example of a scholarship, Okay, so I'm going to share my screen. I'm aware that I only have not more than 15 minutes, so I'll do it very quickly. Just let me know when you can see my screen, because I was thinking that if I can outline it with my PowerPoint, it will be at least clearer for
yes, screen now. Yes.
In January, I have to say, in January, I signed a contract with a different university, Alliance University in India. This is just to update you, since in the last, let's say, bio that I've sent you, I was still at Walter Sisulu University, although Walter Sisulu University is moving to, they want me to basically stay on as an adjunct professor, but my main employment now is with the Alliance University in Bangalore in India. So this is just to update the information. Okay, so I will start with my presentation. So this is how I'm going to organize my my discussion. It will have three parts. The first part, I'll look at the justiciability issue. I felt like I should concentrate on justiciability because I thought that if I was just going to repeat what I've said in the book review, then it wouldn't add any value. So I'm going to concentrate on the disability issue. I'll look at the different constitutional perspective, based, of course, entirely on Dr. Ndeunyema's book. And number 3, I will end with some parting thoughts. But before I even start with the very first part of my discussion, I want to provoke you. Remember that I've said that I'm going to force you to take side, so that in the process, you would be led to read this fascinating book. So the first three provocative hypotheses. The first one is Article 101 of the Namibian Constitution is absurd. It nullifies itself. So the right to water has never been expressly non-justiciable. I will demonstrate what I mean by that. The second hypothesis, provoking, is the structure of the Namibian Constitution suggests that the framers of the Namibian Constitution, what they had in mind was that socioeconomic rights, water, will have to be interpreted in a neoliberal fashion and not in alternative ways. For example, in socialist, transformative, Ubuntu, Re-Invigorating fashion, or and other fashions. And then number 3, I'm going to say that treasury and not judiciary is more capable of solving water challenges, because scarcity of the water makes it more an economic than a legal problem. So let me then start with the first issue. For me, the way I see the core problem that Dr. Ndeunyema tries to tackle can be framed like this. This is how I see it. Despite the acute shortages of water in the driest country in Southern Africa, which is Namibia, the Namibian Constitution does not provide for court enforceable human right to water. So this is how I see the core problem. Dr. Ndeunyema puts it in a very witty way. He's even saying that in a context where many parts of Namibia on average receive low or no rainfall, the courts cannot simply let it rain. So justiciability is more specifically dealt with in chapter 5 of Ndjodi's, Dr. Ndeunyema's book, where he deals with the normative and the practical desirability of justiciability. So he conceptualizes justiciability in relation to water scarcity. And following Olsen, Dr. Ndeunyema draws a cut between natural resource scarcity, which he calls first order scarcity, and social resource scarcity, which he calls second order scarcity. So the argument that he makes in relation to that distinction is that justiciability is more a question of second order scarcity, whereby courts can hold other institutions to account for the management of second order scarcity. I have to emphasize account, because Dr. Ndeunyema emphasizes the role of the courts in ensuring accountability of the other institutions, including the legislature and the executive. And that concept of justiciability, he classifies it into 3 categories: norms, courts, and text. I'm not going to spend much time on the norms because the norms, reading the book, I understand they gain most of the significance from the fact that they are used to overcome the non-justiciability of the right to water. So I'll concentrate more on the courts and on the text, based even on the provocative hypothesis that I've put forward. Okay, so now let's look now at the constitutional perspective. This is to show a little bit of the possible ways in which different perspectives in Namibia, although the skull Claire was American, Judge Olin, Judge Ismail Mohammed were judges in the Namibian Supreme Court. I'm going to look at their perspective in relation to Dr. Ndeunyema's perspective. So I'll look at more specifically 4 approaches. Olin's positivism. Many scholars tend to look at positivism in Namibia when you look at the judges as being epitomized by Brian Olin. So that's why I'm actually saying Olin's positivism. Mohammed, Ismail Mohammed, and transformative constitutionalism. I'll look at reinvigorative constitutionalism, and I'll look at liberal constitutionalism, which is in line with one of the hypotheses that I've put forward. Okay, so the Olin's positivism would be to answer the justiciability issues by saying that while you look at the text, it's very obvious that the Namibian constitution doesn't provide for the right of water. But there are three ways of circumventing this non-justiciability, and I'm not saying that this is what Olin's would have said, but this is how different scholars may try to go around the non-justiciability of the right to water. There is Dr. Ndeunyema's position, which is to say that while non-justiciability could be overcome through reinvigorative constitutionalism, which insists or which submits that water flows from life, no pun intended. And then there is another way, which is one that I've thought for a long time, which is Article 144 of the Namibian Constitution, which provides the basis for the application of international law in Namibia. According to that Article 144, the treaties ratified by Namibia become applicable in Namibia. From the text of Article 144, it appears that, and the majority of academics in Namibia, or who wrote about Namibia, said that it means that it applies, those ratified international treaties apply automatically. Namibia has ratified the International Covenant on Economic and Social Cultural Rights, and that was in 1994. And as you know, that convention deals with the right to water in Article 11 and Article 12. So one way of maybe going around the non-justiciability, at least in my view, is to simply rely on Article 144. But I have to say that the whole interpretation of Article 144 and whether it means that there is direct application of international treaties is currently before the courts. The High Court, the Supreme Court referred the matter to the High Court so that the High Court can deal specifically with the Article 144. Although it's not in relation to the right to water, this case is going to define the application of international law in Namibia. But I have to say, just as part of the academic discourse, that this can be one way of going around the non-justiciability issue. But again, I cannot say because the case is pending. Sorry. Can you still hear me?
Yes, please proceed, Professor.
Okay, no problem. Please let me know when there's about 5 minutes remaining so that I would know at least how to pace myself. I have to now basically explain what I meant by the absurdity of Article 144. So take a few seconds to read Article 101 of the Namibian Constitutions. It says, the principle of state policy contained in this chapter shall not of and by themselves be legally enforceable by any court, but shall nevertheless guide the government in making and applying laws to give effect to the fundamental objectives of the state principles. The courts are entitled to have regard to the state principles in interpreting any laws based on them. But when you realize that Article 101 is itself part of Chapter 11, then you see the absurdity. Because it's basically saying that everything in this chapter is not enforceable by the courts. Well, but that also means that Article 101 itself is not enforceable by the courts. So in logic, if for those of you who may even have done philosophy, you would know that this creates an absurdity. It's like me saying that it's like a statement that it's like me saying that what I'm saying is false. But okay, let me put it, I'm trying to find the best, a good example. Let's say that I'm telling you that everybody in this house is crazy. But if I myself am part of that house, it means that I'm crazy as well. So if Article 101 says, not if, it does says that Chapter 11, where Article 95 is, Article 95, remember, it's actually one of the bases for interpreting socioeconomic rights. If it says that it's non-enforceable and Article 101 itself is part of Chapter 11, then Article 101 defeats itself, it nullifies itself. It's a contradiction in terms. So the consequence would be, well, but if it nullifies itself, logically, it means that there's no express provision that makes Chapter 11 non-enforceable. If you don't agree with me, you are more than welcome to discuss with me in the Q&A session. So let me proceed. So the transformative constitutionalism perspective would say that the Namibian constitution most certainly provides for the right to water. This is what likely Judge Mohammed would have said. Some scholars like Professor Horn looks at Mohammed as a transformative constitutionalist, but given that at the time he was writing, there was no, at least Clarion of Carl Clare, there was no Clarion version of transformative constitutionalism. It's questionable whether he was actually a scholar of transformative constitutionalism. So looking at the origin of transformative constitutionalism, I tend to look at Mohammed more as a critical studies scholar. And then Professor Horn also embraces transformative constitutionalism. He calls it transformative adjudication, and he has written an entire PhD on the topic. But of course, Dr. Ndeunyema's work is very much different from what Professor Horn has done, because Dr. Ndeunyema combines Ubuntu and transformative constitutionalism, which is not what Professor Horn did for his PhD. So reinvigorative constitutionalism basically would argue that the Namibian constitution provides the right to water through life. So in other words, they would argue that non-justiciability could be overcome through reinvigorative constitutionalism, which insists on the fact that water, the right to life subsumes the right to water. So in this sense, I'm repeating myself. I'm not going to elaborate too much on reinvigorative constitutionalism, at least what it stands for, because I think that Dr. Ndeunyema has already done a great job explaining that to us. But I would like to come quickly, and I'm about to finish. I would like to turn to liberal constitutionalism. Some critics, especially liberals, would maintain that socioeconomic rights, including the right to water, could interfere with free markets. And Ndjodi talks about these critics on page 168 of his book. But this can be problematic. Why? First of all, because Article 98 of the Namibian Constitution says the Namibian economy is a mixed economy. Ndjodi also in his book also mentioned about some aspect, the time when it was, the time when the Namibian Constitution was written, the Cold War, but it was Dr. Amupanda who actually at least articulated that criticism by saying, but that if you look at the Namibian constitution, you can see that it's a neoliberal constitution. So looking at the question of the neoliberal character of the Namibian constitution, I'd like to concentrate on capacity and how liberals are likely to attack them. So when dealing with capacity, we have to remember that and Dr. Ndeunyema's book concentrates on the courts. It refers to the problem of at least the criticism that courts lack the capacity to deal with socioeconomic rights through the concept of polycentricity, which is a concept that has been often used to talk about this aspect of non-justiciability. The fact that it's a very complex process to deal with socioeconomic rights. It's like almost like a spider. When you know, a spider web, when you touch one part of the web, it affects the other parts. It's very complicated. While courts, when they deal with matters, tends to be bipolar, not in a pathological way, but they tend to be bipolar because it involves two sides. It's reactive, it's not proactive, and it's based on dispute. So if there's no dispute, they will not deal with issues of water scarcity. But I want to further emphasize even the fact that socioeconomic rights and the right to water affects resource allocation and budgeting. What I'm going to claim now, based on liberal constitutionalism, I have to say I'm not myself an advocate of liberal constitutionalism, but I wanted to highlight this because this is actually a type of constitutionalism that was intended for the Namibian constitution, but that fortunately was never used, but that would explain some of the provisions like the absence of express express provision of certain socioeconomic rights. So the claim that I'm going to make is that except for cases of blatant disregard, judges will not be able, in Namibia, they will find it very difficult to say when the right to water is infringed or upheld. And why am I saying that? If you look at the Namibian budget for this year in 2022, it was tabled by Finance Minister Shimi in February. You could see that the government has made provisions for water. And you can see that they have also made provisions for water infrastructure and refurbishment. You can also see that they've prioritized sectors like education. It's one of education and health are some of the biggest items on the Namibian budget. So given a situation like this, and given also the reality of a shortage of water, how can a judge, how will the judge be able to say that, well, but I think here you have violated the right to water in blatant cases where the government doesn't even make any budgetary allocation, then it becomes obvious that the right is being violated. But in this current case, and given Namibia's reputation as one of the best governed countries, it's not very best governed countries in Africa. It's not very likely that simply by looking at the budget or by going to court, you will put the judges in a position to tell that the right to water has been infringed. And so this is one aspect of judiciability that is not being dealt with. And there's another aspect of what I'm just saying, which is that if you look at Namibia's finances currently, and I'm going to deal with this by asking you a question. How do you supply water to everybody when you yourself are swimming in debt? Swimming in Debt was the title of an article by the main daily, the Namibian, in Namibia. And it was actually giving the figures, which you can also find in the budget speech, where they were basically saying that Namibia's budget, debt has actually gone up to 71% of what the country produces, and that 1/6 of the budget is only used to pay the debt, the servicing of the debt. In those circumstances, how does a government ensure that everybody will, or at least the vast majority of the people will get water when its financial means are actually decreasing? So I'm going to conclude building on this in a neoliberal or liberal constitutionalist criticism, not because I approve of it, on the contrary, but for two reasons at least. It's arguably based on the history of the Namibian constitution, the way it was drafted, what the framers of the constitution intend. Important because since we are talking about scarcity as an economic problem, assuming that you agree that it's an economic problem, then it becomes very important to look at the new or the liberal constitutionalism, because although people don't like to say it often, mainstream economics has by and large remained neoliberal, although people use the euphemism of neoclassical economics. So a few things to think about as I'm concluding. Liberals will say, well, but the Namibian state doesn't have the capacity. When you look at when you listen to Re-Invigorating constitutionalists, you realize that it heavily relies on the state to provide water. But the question that we can ask ourselves, does the state have the capacity right now? Or maybe in the past? But even at any point, you can ask yourself, does the state have the capacity, financial-wise, infrastructure-wise, in terms of attracting the capital needed to build the infrastructure? So those are questions, those are things that liberals would question. And that would explain why they thought, well, socioeconomic rights shouldn't feature in the constitution. So they would also argue that the courts, just like I've been discussing, the courts don't have the capacity either to help the universal provision of water. And yet, and that would be another criticism, the state monopolizes water supply through NamWater. You see, so those are some of the criticism. In the discussion of the provision of water, have we thought about the fact that the state has a monopoly over it and the kind of consequences that it has on the allocation of water to the different communities in Namibia? Those are things to think about. Again, not necessarily because you agree, but it raises question. It's not about don't get me wrong, it's not about the privatization of water supply, which has a terrible history, but it's about thinking about other players. Of course, the most radical liberals will say, well, the problem is precisely that the state is there, you have to get rid of the state. But mainstream economics is still highly contested, and there are many people who agree that it doesn't entail that the government should go out, but it does entail that you have to include other people. What about markets? What about communities? If we talk about Ubuntu, what role can they play in supplying the waters? So this is important for liberals because they will say that, well, the approach that you are taking right now is misguided because it relies heavily on the state when in reality the state is already overstretched. So those are the questions that they would ask, and maybe things that I would like us to discuss, not necessarily to agree, but so that we can discuss and so that you can actually go through Dr. Ndeunyema's book and enjoy the arguments that it puts, even to criticize some of the arguments. Because Ndjodi does, if you look at the—
Are you from somewhere? I'm sorry
Yes.
to have to cut you off, but we are running out of time.
Oh, okay, well, I'm actually done, so that is the good thing. So the last point, and this is like really the last line, is like, water shortages, according to liberals, will criticize and say that water shortages will become worse in the future, whether or not the right to water is expressed, implied, or denied in the Namibian constitution, because the resources of the physical space is shrinking. So by concentrating on those institutions, the court, we may be missing the point that the ability of the government as a state is actually diminishing the ability to provide this. But again, this is to encourage you to read the book. If I were to summarize my at least assessment of the book, I would say that Dr. Ndeunyema's book is essential and it's an exquisite book on the topic that it deals with, the right to water. It will captivate different groups of scholars, constitutionalists, political scientists, philosophers, comparatists in Namibia and beyond. It certainly did fascinate me. And I would say in Kiswahili, to congratulate Dr. Ndeunyema. Hongera sana, rafiki yangu, Dr. Ndeunyema. And I will stop there. I'm sorry I exceeded my time. I didn't know how long it was going to be. Okay, thank you.
Thank you so much. For the sake of time, we're going to move on to our next discussion, and then maybe Ndjodi, you can respond to both discussants once he's finished. By way of introduction, Dr. Caiphus Brewster Soyapi is an academic professional and researcher based at the Northwest University. His research interests focus primarily on environmental constitutionalism within Africa. Within the space, he broadly explores rights-based environmental protection, the place of international environmental law principles in African courts, and African judicial environmentalism. Dr. Soyapi has also written extensively on the right to water in Southern Africa. I'll now hand over to you, Dr. Soyapi.
Okay, thank you so much, Robert. Am I audible? Am I audible?
Yes, you're audible. You're audible.
Okay, thank you. So just a correction on the last part. So I have not written extensively on the issues of the right to water in Southern Africa. I've written a bit on it, but yeah, I should mention at the start that speaking last is by no means an indication of quality. And I'm certainly going to take a different approach from the one adopted by Prof. Zongwe, because as a Zimbabwean, I read this book as more of a watch a backseat driver, as opposed to being someone who's within the country. So my understanding of the issues might be a little bit limited. But I should also mention that I'm not sure if Dr. Ndeunyema would remember, but in 2012, we actually both were in Mozambique representing our universities. And we actually mooted against each other in the last rounds. I was representing Bafokeng campus and you were representing Namibia. And I'm so happy, I should say that. I'm so glad that our generation is starting to make a mark. And I'm so glad that you're representative in this regard. So back to the presentation. So I do not have PowerPoint slides, but I've kind of made notes. And I'm certainly going to read through those notes. And I'll start by saying that it almost feels archaic or unfashionable for countries undergoing constitutional change to not include justiciable socioeconomic rights, including specifically the right to water. and especially considering the various water security related stories the world over. Yet for countries with old constitutions, the dilemma is how do we instill a sense of moral responsibility within the heart of state action, so far as it relates to the provision of essential social economic rights like the right to water? How do we vitiate the divide between an expectation of the right to water and a lack of constitutional protection of such right? Now, as I was reading the book, I'm a big movie enthusiast, and I always try and find an excuse to slot in movie references in my classes. And I so happen to have a very good movie. I would recommend those who haven't watched it. It's a 2011 movie. It's named Rango. It's about a amphibian that's a chameleon. His name is Rango. So I'll just give a brief iteration of the plot, and I'll try as much as I can just to get back to it by way of analogy in relation to what Dr. Ndeunyema has said. So the movie Rango, the plot goes like so. Rango, a chameleon, finds himself in a desert. He is thirsty more than he is hungry. So he follows his shadow into a town interestingly named Dirt. He gets into a bar of depressed animals who are more miserable than he is and realizes that every animal is treating him with suspicion. So he gathers his confidence and lies about killing some gang group with one bullet. The animals are impressed and excited, and they take him to the mayor, whom Rango impresses as well. He's then made the sheriff of Dirt. A lot of acting happens, and through this, Rango realizes the town is depressed because of a lack of water, and that the mayor controls part of the remaining water and provides it in ration portions when he desires. And what happens? He does investigations. He lies about the gang. His lies about the gangs are discovered, and he's chased out of town by the rattlesnake. Interestingly, he finds himself again in the desert, where he meets a mysterious figure named the Spirit of the West, who tells him no man can walk out of his own story. Rango realizes that his thirst is insignificant when measured against the thirst of the whole town and even the small animals that cannot and do not have the audience of the mayor. So he runs back. So in reading this book, I tallied three aspects that I believe make the book unique in its approach and which should be celebrated, especially in view of the current situation in Namibia. At the end, I have a few aspects which I believe could be worthy of discussion, especially because I approach my own work from a multi-jurisdictional perspective. So the first point of celebration, I think it's to be celebrated that Dr. Ndjodi took an expansive reading of the rights to life, or right to life rather, as including the duty to fulfill the right, including through provision of water. Now, how does he do this? Having traced the right to water from international and regional frameworks, the question of the actual or implied provision of the right to water, at least on an international level, is solved because we can find precedent. Dr. Ndjodi then adds to apply this thinking to Article 6 of the Namibian Constitution, which reads as follows: the right to life shall be respected and protected, without necessarily having the word fulfilled, which would normally fall within the classical duties of the state: protect, respect, fulfill. Dr. Ndjodi then clearly argues in the presence of principles of state policies which are considered to be non-justiciable, the right to water can and should be read within the right to life, because a duty to fulfill the right to life requires the state to scaffold life through provisions of services that would sustain it. Now, going back to Rango, the mayor had started buying other animals' lands, claimed that him buying the land was in fact protecting them because it allowed them to move to other towns where they would find water. Yet the mayor was withholding the provision of the water. This clearly falls short of the duties expected of an executive, as it were. And for me, I love the fact that the discussion felt like an open indictment to the state, some sort of hypocrisy to say, you cannot claim to protect the right to life, yet fall short of fulfilling it. The flip side being true, fulfilling the right to life is part of the process of protecting and respecting it. So some intersections there with the rights. The second point to be celebrated is that he was using a bounded deliberative model to require accountability in relation to the provision of water. Dr. Ndjodi accepts that in the absence of express justiciability or even explicit mention of the right to water, it could be difficult to litigate for such rights. He thus employs the ideas of the bounded deliberation model, which is a process of deliberation between the legislature and the courts. Now this is where it gets interesting. So even as critics could claim that, can claim that they do not necessarily agree that certain economic rights are justiciable, when a claim for their justiciability or their enforcement comes before the courts, an argument against their justiciability must be deliberated in the sense that the legislature or the state must account for why certain positive duties have not been or cannot be fulfilled. In other words, even as we disagree with the decision of the state or legislature, we should be able to see the reasoning and justification of the state. Courts will then be able to also deliberate on the reasonableness of the account and justification given by the state within the bounds of human rights. Now, going back to Rango, even as the mayor had these big ideas about a modern city, he was planning this at the expense of other animals' water needs, many of which were vulnerable and poor, without justification or account. When confronted about this by Rango, instead of explaining, in quotes, bounded deliberation, his solution was to chase away Rango. So for me, what bounded deliberation does is to sort of allow the state to dig its own grave, in a manner of speaking, as then as an institution with a democratic mandate, it has to explain why and how deprivations of the right to water, for example, could be consistent with their democratic mandate, which in this case partly includes to protect, to respect, and to fulfill rights. So to me, this ties in directly with a purposive approach to interpretation and altogether the purpose of institutions like the legislature and the executive. And the third and last point, which in some ways I thought it also spoke to the concerns which Prof. Zongwe has, the idea of situating a minimum core through the ACWA nomenclature. Now, in linking the rights bounds of the human rights bounds of a deliberative model, Dr. Ndjodi argues for a minimum core, which terms ACWA, availability, quality, and accessibility. For Dr. Ndjodi, as a normative minimum core element of the right to water, ACWA ties into the duties owed by the state to the collective populace, communities as it were, which, when viewed within the communitarian ethos of Ubuntu, would imply that a failure by the state to meet this minimum core element is not just an affront to the rights of the individual, but precisely its social contract responsibilities, as it were. Going back to Rango, we see that Rango is in fact after his lies are found and upon being made aware by the sheriff, he becomes a victim of thirst in his own right. Yet in the quest to find out what could be done, his confrontation with the mayor becomes one of concern of the town. And he says to himself and to the TV, for as long as we have water, we have a town. And this speaks to the communitarian aspects that I espoused through Ubuntu. So really, I think overall, Dr. Ndjodi comes to logical conclusions in the book, and the reflection that I have now as points of discussions and maybe some questions should be colored by the fact that I'm not well aware of the context in Namibia and the aspects of re-invigorative constitutionalism. But the first question really is because of interest, right? So in reading chapter 5 on the issues of polycentricity, where multiple institutions are tasked with dispensing positive duties, as it were, I thought of ideas of local government and basic services. So for example, if you look at section 152 of the Constitution of South Africa, there are some sections in the Constitution of Kenya, Uganda, and Zimbabwe, that's 175, 176, 265, and all in differing ways, they require local government to budget for and to plan for basic services. So I wondered, how is the framework in Namibia, and could this not be a backdoor channel, for example, to argue for the right to water through constitutionally mandated local government provisions requiring basic services? And I mentioned earlier on that I work within a multi-jurisdictional context. So I thought as a Zimbabwean as well, like what would be the value of reinvigorative constitutionalism for the broader African space and also from a Southern African perspective as well? So right, in situating the discussion and then maybe in trying to buttress the argument for reinvigorative constitutionalism, the argument, as I understand it from the initial page, is that Ubuntu is employed as part of reinvigorative constitutionalism for a reading in of the right to water, or for imputing the right to water as a derivative from the right to life. A narrow reading of the ideas of reinvigorative constitutionalism is that it potentially finds currency because the right is non-existent, and a communitarian reading of the existing provisions through reinvigorated constitutionalism allows a reading in. But what if Namibia amends its constitution and includes an explicit provision Could we still speak of reinvigorative constitutionalism? In other words, what's in it for countries like South Africa, Kenya, Zimbabwe, which already have these provisions? That's this idea of reinvigorative constitutionalism. Secondly, and a bit of background, Zambia's president signed the constitution. I realize I've run out of time here. Am I allowed to finish? I've only got 2 points further to make. Goodness, am I?
Yeah, sorry, my video got stuck for a second there. Yeah, sure, you can wrap up. That's all right.
Okay, I thought for a second I was speaking to myself here. All right, so the other part really speaks to, and this is an example from Zambia. Zambia's draft constitution from 2014, it had an explicit right to water. And the final constitution in 2016 did not have this right to water. So in arguing and in buttressing and in making a case for reinvigorative constitutionalism, what do you think would be the worth in countries like Africa where they are regressive in this way? You have the right in a draft constitution, and then you remove it in the final constitution. And lastly, so because I think the book seeks to develop new legal ideas, and you rightly mentioned so, and escape from old ideas, and the nomenclature or neologism chosen would be the one of reinvigorative constitutionalism through African values. The question is, and I'm expressing just my confusion here with the ideas that I usually espouse when I hear the phrase African values. The question is, absent Ubuntu, what other values can we really impute in trying to make a quest for reinvigorative constitutionalism? And a related question is, if Ubuntu already exists, could we not Ubuntuify our understanding of present values like dignity, equality, etc.? And that's about my contribution. And again, thank you so much. And thank you to SAIFAC for allowing me to be a part of this process. Thank you, Dr. Ndjodi.
Gropa, are you having trouble unmuting?
Sorry, yeah, now I'm back.
Okay, Ropa seems to be having some trouble with her mic. Ropa, if you're not back. I think the next stage was for Ndjodi. Please, would you like to give a short reply, and then we kind of want to also allow for other questions, because there are other attendees here. I know I have lots of questions, but we won't be able to cover all of them, but we do want people to be able to answer questions. So people can post them in the chat, or we can just, we're a small group, you can feel free to just put on your audio or your video and ask the questions. So Ndjodi, perhaps can you just give 5 minutes? I know there are lots of points, but 5 minutes and on one or two of the key points you wanted to respond to, and then we can invite some questions, and hopefully Ropa's mic is back soon.
Yeah, thank you so much, Professor Zongwe and Dr. Soyapi. That was really, really provoking and enriching, and I'm really delighted that you gave serious treatment to the ideas and writing in the book. Yeah, there's so much there, so I don't even know where to start. So perhaps Dr. Zongwe, and hopefully we can have offline conversations to take further aspects, specifically on the issue of the principles of state policy. So the argument in the book, as you clearly state, is a short, rather laconic one. And I decided to deal with that argument of the principles of state policy more broadly outside the specific right to water context, but more so in the social economic obligations of the state context, in a different article that has come back with a revise and resubmit. So hopefully it will be in the public domain soon. But basically, I then critically engage with Article 101 along the lines which you suggest of the absurdity that the provision suggests, but that absurdity only existing if you apply a particularly absurd interpretation to the Constitution. So hopefully that article can then elaborate upon that issue of principles of state policy, in a much more expansive way. The Treasury versus judiciary point of view is a very interesting one. I'm glad that you brought into the debate this issue of fiscal considerations, economic considerations, the current economic situation that we face in the country. I think that practical element is very important, and probably a practical rebuttal to assertions of the right to water, and perhaps why even courts would be trepidatious in terms of recognizing a right to water. But certainly I do believe and argue for space for courts in using the deliberative model, particularly holding the various organs of state to account, specifically the judiciary, the executive and legislature, in their various forms, whether at a central government or local government level. So that's really interesting. The issue of the capacity of the state, yes, I focus on the state, but there are other actors. I do focus on the Namibian state because I argue that they have the capacity, and in many respects, they're also capable and potentially culpable directly as regards the failure to realize that at that very basic level, minimum core that everyone has with respect to their right to life. Dr. Soyapi, again, thank you so much for that very artistic and creative way of reading my book and the arguments. Very interesting perspectives that you've introduced to the fore. Perhaps I'll focus on your specific questions that you've raised. So the issue of polycentricity and local government and whether the right can be asserted at that level. Very briefly, our constitutional setup and the political setup is such that the power of the state is centralized in the executive government rather than the decentralized models that we see in jurisdictions such as Kenya, for example, which you referred to, where there's a move towards devolution. So the debate can happen in the Namibian setting as to whether or not that centralized approach to governance is appropriate, but that being the political status quo, the focus is definitely on the state at central government level, in as much as we do see local authorities often being at the forefront of water disconnections and so forth, and they could potentially be held to account, but they ultimately require the state centrally to come to the table and fulfill those obligations. The amendment of the constitution point is a fascinating one. It's one that I think I also want to provoke within the Namibian public today, because the approach to the constitution is the chapter 3 is such that you cannot derogate from chapter 3, but there's nothing that prohibits one from enhancing chapter 3. So the argument could be that this implied right to water argument is redundant if there's political consensus to include socioeconomic rights such as water, health, food, and so forth expressly in chapter 3. So potentially something to think about there. In terms of the viability of reinvigorative constitutionalism beyond Namibia, I think, and the design of reinvigorative constitutionalism, rather than just directly utilizing Ubuntu, was deliberate, such that we can think of our post-colonial constitutions in this way where we take back ownership of the legal culture, utilizing the very language of Karl Clare in transformative constitutionalism, by being deliberate as regards the infusing of African values in our constitutional setups in an African setting, recognizing that imperialism also took the form of legal imperialism. So that's the deliberateness within which reinvigorative constitutionalism is adopted, applied, and developed specifically in Namibia, but also with a philosophical and theoretical undergird that can have currency beyond Namibia. In terms of Ubuntu, what else? There are scholars who have a certain other communitarian humanist principles, but the provocation is for us to also think about values, norms, practices in everyday society, even society at a micro and meso level, and then give those values national and regional significance. So I definitely wouldn't be able to exhaust which other values other than Ubuntu should be asserted. But the provocation is that hopefully the philosophy and theory behind reinvigorative constitutionalism will then allow people to bring this to the fore. All in all, thank you both, Professor Zongwe, Dr. Soyapi, and on the point of our generation of human rights thinkers and scholars. I regard our time in Mozambique during the African Human Rights Moot Court as the time where my passion and drive and understanding of human rights was fomented. So I'm really glad to be sharing the virtual stage with you and in hopefully channeling ideas that will impact African lives.
Thank you so much, Ndjodi. I'm just going to open up the floor to anyone else who has questions. I think, Prof. Gilshitz, you had a few.
Great, thank you very much. I know we've slightly gone over our time, so we have a few people who've left us, but I think the point is to actually have a discussion. And firstly, just to congratulate you, Ndjodi, a fantastic book. I have read a little bit of it, and I want to read the whole thing in depth. The congratulations on it. It sounds absolutely fascinating. I have many aspects which I wanted to ask you, but we don't have a lot of time, so I'm going to confine my comments to two, I think, initially, and allow for other people to ask as well. Hopefully, if not, we do want to definitely finish in the next 20 minutes. So I wanted to ask you firstly about scarcity. Actually, it's an interesting question. Professor Zongwe raised this and sort of said, well, there's going to be more scarcity. And my sense is actually scarcity is less. I understand the economic resources problem, but actually we have the technology now where there shouldn't be water problems anywhere, basically, right? Desalination is an extraordinary technology, which basically means that in water scarce countries and which have a coast like Namibia, it's potentially possible to have enough resources to provide for everyone. Now, I know there's a problem of getting the water across the country, and that's obviously a complex problem and an engineering problem, but the actual physical scarcity of water, I realize also countries like Namibia don't yet have significant desalination plants, but surely that's a requirement of progressive realization then, is to actually utilize all technologies to ensure that the country becomes water sufficient in and of itself. So that's my first question to you, to ask you about scarcity and actually whether or not we can move to a point where we actually don't need to debate that the actual absolute lack of water. The second question relates to the minimum core, which, as you probably predicted, I was going to ask you about. And I was a bit confused, Ndjodi, about what your views on the minimum core. And I just want to read from your book. You say this here, and an Ubuntu-inspired approach to the minimum core is also instrumental in ensuring that those obligations that the state is to discharge are framed such that they move human interest from the periphery to the center. The aim is to safeguard the sense of Ubuntu in the dignitarian sense of individuals and communities given their inextricability. Ubuntu thus allows us to counteract the potential limitation of an understanding of the minimum core scope as referring merely to those minimum essential levels of water that relate to human survival interests, right? And you reference my work. A right to water would be significantly diminished if only the minimum essential levels for human survival were obligatory. Indeed, neither would Ubuntu as a reinvigorative constitutionalism paradigm or transformative constitutionalism counter such a narrow interpretation. And I suppose I was just wondering how you conceptualize, am I still audible? Yes, I am. I was just wondering how you conceptualize the minimum core from an Ubuntu perspective. Like, it seems to me what you're saying there is ultimately the minimum core is everything we want from the right to water, which is not what the minimum core, in my understanding, is that it's a priority level. So everything we want from the right to water is what I call the sufficiency standard. It's the higher level standard towards which we need to progressively realize. The minimum core is the provision for a priority level to those people who actually really lack water, who are in a situation where they're virtually without any water at all. And so I want to understand from you, how does Ubuntu help us define that threshold in a very practical way? Because I want practically to say, you know, the minimum core is going to ensure that people have enough water to be able to drink, to survive. They may actually not have all the water they need for every other usage. Probably it's going to include sanitation and maybe one or two other things, but it's not necessarily going to be every demand for water that they actually need. So I'm interested to hear from you how you capture that threshold from an Ubuntu inspired approach. And I'm going to leave it there because I've got many more things I want to ask you, but those two are enough for now. Thanks.
Thank you so much, David, for those reflections. They're really enriching. I'll try and address them very briefly, but I think there's a lot of food for thought there, especially on the minimum core aspect, which I'll come to in a moment. But from the scarcity point of view, yes, there is technological development. Namibia isn't there yet. There are debates at higher cabinet level as to whether or not we should invest in state-sponsored desalination. The challenge of distribution for purposes of access is a big challenge for Namibia. So, for example, just shipping or piping water from the coast to the central capital city, Windhoek, alone will require a mammoth amount of investment, which then perhaps introduces sort of private investment debates into the picture, because the fiscal space, as Dr. Zongwe was referring to, is just at this stage at least non-existent. But the vastness of Namibia also creates a challenge, because water is in many ways an individual and community right at the basic level. So and people decide where to settle. You can't necessarily impose, and that obligation still exists. So irrespective of where someone is, the state has to go to the people rather than the people coming to the state in terms of state infrastructure and so forth. So I think that's why then having technical people join the debate when the normative argument is solidly made is very helpful, and that's the sort of thinking that I'm moving towards in terms of engaging people in that direction. Minimum core, so the argument in the book is predicated on first justifying from a legal, constitutional, normative point of view that the minimum core also exists in Namibia. The next stage would be to then develop that minimum core, pay careful attention to those very issues that you define in terms of what that basic level is, and the practical application of that minimum core. Now, fortunately, especially under various tools at regional and international level, that minimum core has started to take shape. So we wouldn't necessarily in a Namibian context be reinventing the wheel. So it's to, I guess, pay careful attention, hopefully in a more particularized context where there is a right to water claim that is brought, and then we have overcome all those normative questions, and it's a question of how then the courts identify and define the state's obligations at a minimum core level. So yeah, I'll end there for now.
Thank you so much, Ndjodi. We've got a few questions in the chat box, but I'm just going to give over to Natalie first, since she has her hand raised. Natalie, you can go ahead.
Yeah, maybe just to add a few points, or one thing maybe specific Namibia here, talking about a water supply. I do also see another issue, or another interesting thing to acknowledge. That is about the service providers. I'm talking, for instance, about the city of Windhoek. When it comes to water supply, there's a lot of complaint and unprofessionalism regarding the accountability. There are a lot of institutions or are not paying for the water bills, and also there are sometimes the system and the infrastructure of the pipeline are quite not the best, to put it diplomatically, and sometimes there are water just bursting out, pipeline broken, and so forth, and people get accounted for that, for instance. So even when it comes for the institutions, for the state or the capital who is taking care for this service, there's a lot space for improvement regarding that. And it's also, when we're talking about water, that must be also or shall be also take into consideration what is the obligation of the governmental institutions regarding the service providing and uplifting the infrastructure, so that everything is equally when it comes to the bills and accounting for that services and water consumption. Thank you.
Thanks a lot, Natalie. Ndjodi, I'm just going to read the two questions together that we have in the chat box, and then hopefully you can just respond to them together for the sake of time. So the first comment is from Cosmos Amazim. I hope I'm pronouncing your surname well. He says, congratulations. I'm happy I was able to join you. I will definitely read the book. I wonder how we can overcome the policy gap on water rights, especially in light of the strong difference to market approaches to socio-economic rights, such as water. And then the second comment is from Skulile, who says, thank you for a very thought-provoking conversation, everyone. Interesting question regarding water scarcity, David, especially if we also link it to the South African context, where water shortages have been prominent in areas like Cape Town and Joburg, which are coastal cities. So Ndjodi, if you'd like to respond to those comments.
Yes, there are comments, so probably just reflect on them. And to start with Natalie's comments on the water situation here in the city of Windhoek, yes, those issues are definitely rife. Water infrastructure is a problem, and if it's a problem in a relatively well-resourced municipal setting such as Windhoek, you can imagine what is happening in the rural areas, right? So that's where the accountability element, I think, plays a useful role, where the courts can hold to account using their institutional power fortified by the law.
I think we've lost Ndjodi.
And let's perhaps give Ndjodi a moment or two just to get back his connection. We are battling internet trouble as well. I see Ndjodi has gone off, I see here. We are nearly at the end of the event, so let's just give maybe 1 minute or two for him to just join us back. And if not, I think we will have to close it.